welcomes all. Thanks for stopping by, answering the call. Ups and downs are normal for some of us. Many days I beg to get off this life bus. Neon lights flicker, a shadow on the wall. Dreams on the ceiling, we run and then we fall. Sharing stories over paper cups. Wheels keep turning but never enough. Life's a ride on a rickety old track, holding on tight, never looking back. In the rubber remodel room, we confide, laugh, cry, love in this crazy ride.
Well, hello, everybody. Welcome in. So first I'm going to do just a basic review. I want to just kind of go over I just want to go over the basics of the case first, and then we'll watch the hearing. So the story is about Jocelyn Nungaray. Now, she became a worldwide, I would say, household name after the elections came up. Hey, Maria, how are you, love? She became a household name when the elections came up, and Donald Trump ultimately used her as part of his election. Anyways, I'm not in the political part of it, but there are things happening in this case that needs to be talked about. So what I wanted to go over was just do a quick review of actually
Developing news today, just so sad. A 12-year-old girl killed and left in a creek, and police need your help finding the killer. We were there this morning at the scene of this gruesome discovery at 6 a.m. when officers recovered the girl from a creek in North Houston off of Rankin Road. Fox 26's Abigail Dye joining us from Houston Police Headquarters. So, Abigail, what are they saying tonight?
Well, Rashi, that's the hard part about this investigation.
I can't adjust the volume, but this is the original video of when the crime happened from our local news channel.
Police aren't releasing much. They didn't give us any details on what condition this girl's body was found in, how she died, or who she even is. They're trying to keep all of that under wraps to not hinder their investigation. But they did tell us that they think this girl snuck out of her apartment around 10 p.m. last night, and then she was found around 6 a.m. this morning. So somewhere in that time frame is when she was killed. This case so heavy that the mayor even joined in on this press conference.
I've spoken to her mother. She's devastated. Actually holding out hope that it's not her daughter, which I'll let the lieutenant address the circumstances. I will say it makes me angry that we have dangerous criminals on the streets of Houston. Too often we rearrest repeat violent offenders, but we won't rest. And this is an example of why public safety will continue to be our highest priority.
Now, taking a look at the area that she was found, we see a lot of evidence of homeless encampments around and under the bridge that is Rankin Road there. Now, officials say at this point, they don't know if this young girl was killed at that location or if she was killed somewhere else and transported there after the killing.
Abigail, I know they didn't release much information, but how do they know that foul play was involved here?
Rashi, I mean, that's a great question. It's one that I'm sure everyone watching this at home is wondering. How are they sure that she didn't slip and fall? How do they know this wasn't an accident? Well, police aren't releasing the exact details, but they do say that they're sure that someone else was involved here, and they want that suspect behind bars.
We believe somebody did this horrible thing to her, and we are here to ask for your help to find out if anybody knows anything, anybody saw anything, and anybody can share that information so we can figure out what happened to her exactly, and we can find whoever did this and get them off the street.
Okay, so I'm going to stop there with that one. So then they end up finding the two gentlemen that do this, and there's actually more than two, but the two, they're pointing the finger at each other. And this is just the kind of like little news rundown of theirs. This was on July 23rd, 2024. Children. Okay, that's not. Court documents are revealing some new details in the death of 12-year-old Jocelyn Nungaray. They state that Franklin Jose Peña Ramos and Jonathan Jose Martinez Rangel are pointing the finger at each other for Jocelyn's murder. Court documents state that Ramos said he and Johan left Ojos Locos, which is a bar, on foot around 10 p.m. and began walking back towards the apartment where they were staying. He said along the way they got lost and ended up at a gas station where they met Jocelyn. Documents state that Johan and Jocelyn, they had asked Jocelyn for directions to get back to their apartment. Along the way, court documents stated that Franklin said that as they were walking westbound on Rankin Road, he saw Johan kiss Jocelyn on the lips. Franklin then stated, according to court documents, they continued walking towards the southwest side of the road where the embankment slopes down onto the bayou. And I'm going to share this tab instead because this is the two pictures of the two gentlemen. This is Franklin and Johan. These are the two gentlemen. At this point, Franklin stated he saw Johan, who was behind Jocelyn, wrap his forearm around her neck. Johan then kept his forearm around her neck and walked her out of the area under the bridge. Franklin then stated he saw Johan put Jocelyn onto her back while she was on the ground. Stated Franklin saw Johan take off Jocelyn's pants and climb on top of her while holding her arms down. Documents stated that Franklin told Johan to stop and that they should leave. However, Johan told him, "I have to finish what I had started." Franklin then stated, according to the court documents, he saw Johan wrap his forearm around Jocelyn's neck, again covering her mouth with his hand. It was at this point the court documents stated Franklin saw that Jocelyn was deceased and Johan tied her hands and feet together. Johan then moved Jocelyn into the water and said that no DNA would be found on the body due to the water. And there's a lovely little picture of Jocelyn. According to the court documents, Franklin stated he didn't touch Jocelyn or physically sexually assault her. Oh my God, and there's a bee in front of my screen. That was scary. Franklin also stated, according to the court documents, that he asked why Johan shaved his beard, and Johan told him, "So that they don't recognize me." Franklin also added he didn't know what happened to his or Johan's clothes after the murder, but he believes Johan got rid of them. During Johan's questioning, he pointed the finger back at Franklin. Court documents say that Johan initially distanced himself for the commission of the murder and claimed that Franklin was solely responsible, and the interview was initially completed. However, Johan reinitiated conversations with detectives and, according to court documents, admitted that he was the person who tied Jocelyn's legs and told Franklin to throw her body in the bayou because the water would wash off the DNA. Both men remain on bars behind capital murder charges on $10 million bond. So, we are going to, hey, Abellas, hey, love. So, this is Jocelyn's family that spoke out.
I got the news about when I watched the second plane hit the towers. You know, I'm not going to forget that as much as I'm not going to forget that day of that. That's, I believe that's going to stay within me as much as when I got the news from the World Trade Center. I remember exactly to the date what I was doing when I got the news about when I watched the second plane hit the towers. You know, I'm not going to forget that as much as I'm not going to forget that day of being woken up to the news of, my granddaughter.
Yeah. So it's been a little over a week since you guys, we all found out about Jocelyn's death and murder. How's it been like for the family?
Oh man, it's rough. My daughter, we we kept hoping and praying that Jocelyn was just missing. And I kept telling Lexi, like, I said, watch, baby girl. I said, that little girl's going to walk in through the door and be like, I'm sorry, and with her little shy self, but as the days went on, we got the news and we were waiting for the dental records to be confirmed. So it's just hard. It's rough. And even now, we met up at the cemetery without speaking to each other. We just both showed up. I mean, and just to go spend some time with her. And it's going to be almost impossible to get rid of this feeling of lost, of, she was going to be a beautiful woman. And she was very determined. She would have accomplished anything she wanted, So it's rough on everybody, on my daughter, on her mom's side, their grandparents on that side. It's rough on everybody.
And I know we're finding out just horrific details. It seems like, things are being confirmed. What have you heard from the district attorney's office and everything regarding the investigation and the forensics? Well,
according to the DA, she told my daughter that that they got the results yesterday afternoon, and that they were waiting to separate all the details to the amount of DNA or what kind of DNA, so that they could explain to us better some way, somehow.
At the time of this recording, Kim Ogg was the district attorney for Houston. It has now been changed, and the district attorney for Houston's name is Sean Tier. And he is now having problems with Kim Ogg still speaking on the topic and giving away things. So that's why we're here today with a possible contempt hearing against Kim Ogg, the former DA of Houston, for speaking too much on this case, and that can cause problems with the trial.
Well, the news got out. So as of now, we just know that the tests are positive, positive for sexual assault. So bittersweet news, because then now we can focus on, whether it's the death penalty and the bond goes out the window. So that my biggest fear was that, getting into politics with Venezuela versus U.S. and, their president over there has the means to get these boys out. And that was my fear, but with this new evidence that's come up, that fear is, somewhat gone. And I know that they will respond and pay for their horrific crime here.
And you said that, it's kind of bittersweet for you all because it does changes how this plays out in court. Melfi, you were in court, and luckily this, what we all thought it would be. So for you, how are you feeling that these guys could potentially have the death penalty?
I don't want they die. I don't want the penalty for them. I want to remember Jocelyn the rest of their life.
You hear that? That's coming from her mother. She does not want the death penalty from these two Venezuelan immigrants who came into the country illegally and essentially murdered her daughter. She wants them to remember Jocelyn the rest of her life. And that's touching for a mother to want that and not actually want the death penalty for these two gentlemen that horribly took her daughter.
In prison.
I think death penalty, it would be an easy way for them. I want every time they go to sleep, they remember what they did. And show to the others You don't mess with our child. You don't mess with United States. You don't mess with Texas. That's going to be a message for all of them. Don't mess with us. Because we're going to get him. And we're going to make it justice.
And I know it's been tough for you and the family. How's Alexis doing, your daughter?
She's floating.
Process is hard.
She's floating. She's going through the emotions. She's not able to go to work because even though in her conscience she feels that she would mess up and she doesn't want to lose her job. So she'd rather put herself out for a while until she can regroup somewhat, if we can call that regroup.
I did
so
not
that
know
she
that,
can
Maria.
be good at what she does, and be 100%, which I don't know, again, if that ever be possible, right? But
especially for a single mom. She's a single mom.
These are the grandparents.
And,
I'm sorry,
one
not
of the
parents. They're
hardest things
grandparents.
for her
I
and
said
for
parents.
all of us is explain to 5 years old that he's Sisi. It's not be at home no more.
right.
He asked for her. I want to go see Sisi. And it's really, really tough to explain him. She's in heaven. I told him she's having fun. She's in a beautiful place next to Grandpa, my dad, and try to explain him the best way we can, for a little one. It's not easy thing to do. He always asks for her. He want to go see her. Alexis say, well, you cannot see her. Well, I want to go where she at. He's very smart, sweet boy. And always, see, And now they take the baby away from her brother.
And we've seen the story just grow on such a national scale. How is the family reacting to the fact that, the Lieutenant Governor is trying to make laws change in Jocelyn's name?
God bless him. Because at the tail end of the day, I wouldn't want my daughter's accident to just go as another statistic for the city of Houston or the state of Texas. I want to take the opportunity to make a difference so that no family, no American family or anyone should be going through this. I mean, we shouldn't have to be in court. We hadn't even gotten the body of our granddaughter, but we're having to be in court on Monday morning and on Tuesday because we had to go show our support so that the judge, Judge Hill, which he did a tremendous job as well by not being so lenient as he has been in the past. And that was our biggest fear as well. I mean, so besides the loss, there was a roller coaster of emotions, of the unknown, on the let's get it right, let's do it right. So we want to change that. So if this ever happens again, families don't have to, they don't have to wonder what if. They're just going to, mourn, grieve their loss and know for a fact that the system is not going to fail us. And whoever does these things, they pay. I mean, whether they're Hispanics, Caucasians, African Americans, Asians, it doesn't matter. Good is good and bad is bad. And we have them in all, so, but we just want to make a difference for Jossie. We don't want Jossie's memory or name to be easily forgotten. That's my biggest concern.
And when we talk about the scale of grandness that this story has become, even former President Donald Trump calling your daughter.
Yes.
What did she tell you about that call?
She is so surprised. She is so amazed the amount of attention that Jossie's gotten. And, she would always say that she wanted to be a superstar. And so I think that we need to continue on her dream. And under the circumstances, which are not the greatest, she will become a superstar. She was already a star in our lives, but now we're going to make it worldwide. And with, former President Trump reaching out, my blessings to him, and God bless him as well. And, I understand that this has gotten so much attention that it will probably be a political base, right?
Unfortunately, it
But
became political, but
I want them not just to use my granddaughter as a political base, but to know her name.
know
It's
her name,
Jocelyn Nungaray.
Jocelyn.
And just, and just help us get everything achieved for Josie.
That not happen again to another family.
Right.
That's exactly what we want. This is actually the consequences to the open water. It should be prevented.
And you said it yourself, that it is being politicized, but at the end of the day, we're talking about a human life here.
Correct.
Jocelyn Nungaray, as you just said. Just confirming again, the district attorney, those forensics did come back positive. So now, did they provide any more details on how they'll move forward with the case?
No, I don't know anything. The DA called my daughter, and I haven't touched base with her today on what the next step would be. But I'm sure that we're going to want to expedite this. That way, we can just remove the bond, and then just it's something that, again, my daughter and I were going to have to. Well, the family, we're going to have to sit down and, like my wife said, if we give them the death penalty, to my understanding, they'll be segregated and be 23 hours lockup, 1 hour son, but they're living alone. I'd rather for them to remember this in general population, life without parole. That way they can remember every night when they go to bed the horrific deal that they did to our family. So.
That's all the questions. I don't know if you guys want to add anything else.
Just appreciate all the media, all of y'all. You've been so helpful. The mayor, oh my God, God bless him. He was, in this case, day and night, or the police officer, first responder, being all of it. The community helps so much. We really, really thankful. Alexis, she's very thankful for that. She's a single mom, try to do the best for her children. And breaking her heart like that is something that we're going to have to help her to heal a little. Not forgetting, but heal, She's very thankful for all of you.
And I think the mayor said it best at the funeral, that the city of Houston is not behind her, and that the city of Houston is her family. So
yes.
I just want to thank you guys for being so open and talking to us.
Thank you.
Day after day. I know it's hard just reliving this thing. So thank you.
Thank you, Janet.
Okay. So there's that one. We're going to switch over to this. This was on June 25th, 2024. This is when the murder suspects were expected into court.
Stories here. One of the two men accused of killing 12-year-old Jocelyn Nungaray will be held on a $10 million bond. Now, the judge ordering that unusually high bond for Franklin Peña after deeming him a flight risk here. Now, this morning, the second man who was charged in this murder will be standing in front of a judge as well.
Both of these men are Venezuelan nationals who recently entered the country illegally. Shelby Rose is live outside the Harris County Courthouse. And Shelby, we did learn new information during yesterday's hearing.
Yes, good morning. Now, the state did originally request a $5 million bond for Franklin Peña, his attorneys countering with $1 million. But the judge, as you said, ultimately did deem that he was too much of a flight risk, which was a reason for that $10 million bond. Now, during his arraignment yesterday, it was brought to light that the two suspects allegedly asked Jocelyn for directions shortly after meeting her on Kirkendall before the murder. The state presented evidence indicating that Peña, who works in construction, requested money from
his boss to leave town afterward. We also learned that he was still wearing an ankle monitor that was given to him by ICE when he was originally detained at the border last month.
Okay, y'all heard that, right? He already was on an ankle monitor because he was detained by ICE a month prior. So he was already on an ankle monitor. Keep that in mind.
And as the charges stand today, District Attorney Kim Ogg says neither suspect is eligible for the death penalty, but says that could change as the investigation is ongoing and tests are still being run.
Should those tests produce evidence that would support a charge of sexual assault, or should other evidence be brought forward that supports a charge of kidnapping, both underlying offenses would make this capital murder and these individuals death penalty eligible.
And Ogg did say they will request the same $5 million bond for Johan Martinez, who is scheduled to be arraigned at 9:30 this morning. Although something to note, it is the same judge presiding over the case as well. That was also with Peña yesterday morning. Reporting.
Okay. So, what I'm going to share next, this is the interview that Kim Ogg did that got herself into a little bit of hot water.
Tonight, I'm joined by Fox 26's Abigail Dye. We have learned here today that a judge silenced former Harris County DA Kim Ogg because of some of the reporting you did there last week about this in a one-on-one interview.
This is some of the reporting. I don't have the whole thing, but the kids are being good, Hannah. Shh, don't jinx it.
That Ogg was going to drop this information on me last week. This is the first time that this was made public. She told me that Franklin Peña, one of the men charged in the rape and murder of 12-year-old Jocelyn Nungaray, has been accused of rape before of an American woman in Costa Rica before the Nungaray case broke. Why are you sharing this now?
Because I am very concerned about the decisions that my successor district attorney has been making. When she reported it to the authorities in Costa Rica, they did nothing. And so imagine the frustration of that individual. I do not want that to be swept under the carpet. I think it's important for the public to get the final say. What I don't want is some backdoor deal done in the quiet of the night and a long time from now, once people have forgotten the horror of this case.
Now, today the state filed a motion to revise a gag order in the case that's been placed there since September to include former prosecutors and witnesses in the case, naming Ogg specifically. And they had some choice words about the whole thing in court today.
An extraordinary.
This is Sean Tier. This is the current district attorney. Kim Ogg is no longer our district attorney.
Grossly inappropriate and just abhorrent violation of the rules of professional conduct.
I'm sorry, Joshua Rios.
Former district attorney Kim Ogg. Who would have thought that the district attorney, the former district attorney of Harris County, would just take it upon themselves to go on television and just leak confidential information because she believes that she disagrees with the current district attorney's decision making, and that she just believes the public had a right to know.
The judge did not sign that order today, saying that it needs further review, but did issue a verbal order gagging any former prosecutors from commenting on the case publicly, and that includes Ogg. Peña's defense asked the judge to hold Ogg in contempt for the interview, but it's not clear if that's possible.
She has done significant damage to their ability to defend their cases. I don't know if it's going to be a contempt situation because she wasn't specifically named as a party to the gag order before today. And so I don't know that the judge can specifically hold her in contempt. But in almost 40 years of practicing law, I've never seen a former DA do something like this. It's very unusual.
Now, Peña's defense and the state both say that they are filing grievances with the Texas State Bar over this issue as well.
Where is Kim Og in all of this? That's a lot of developments. Have you had a chance to speak to her today to follow up?
Yes, so we did speak on the phone today, and we talked at length about the interview and what's happened since. But at this point, Kim Og is not going to publicly comment on the case.
Good work, though, getting that interview in.
And this was recorded June 2nd, 2025. So what we're going to go over here and we're going to watch the hearing that happened today.
Arlene, you're good? Yes, sir. So we're hearing clause number 187-3327, State of Texas versus Franklin Peña. Just want to make sure we have, okay, got the interpreter, got him out. That's good. This morning I filed an amended order concerning extrajudicial statements. I believe everybody has a copy, has had a chance to look at it. I wanted to make sure something was put in place in writing fairly quickly. Obviously, as the last line says, this can be amended, things can be added to it if need be. But I think this, at the very least, covers all of the rules of professional responsibility, penal code, code of criminal procedure, rules of evidence, and other requirements of all lawyers. And then there's certain aspects that apply specifically to the state. And it does include verbiage that this applies to all former, current, or future lawyers and their staff that have anything to do with this case. Obviously, in the case of the district attorney's office, that's a large law firm, so it would include everybody within that office, previously, currently, or in the future. And for the defense, anybody who is formerly, currently, or in the future employed or touches this case, so to speak. In terms of limiting speech or communications of people other than the lawyers and employees of the law firms and stuff like that, as we get closer to trial on the eve of picking a jury, things like that, it gets very easy legally to limit all kinds of communication if it is necessary to preserve the integrity of these proceedings. To do so sooner, I am all ears and I will listen to whatever requests are made. I just wanted to make sure something was put out in writing so we could at least have something now as a placeholder for whatever may come in the future. But any questions, I guess, about the protective order first before we jump into any other things?
I do have some questions.
Okay.
Judge, I would first, and I think counsel will agree with me on this, to be clear,
okay,
I still believe that former District Attorney Kim Og was covered under the prior order, okay?
Yes.
And the need to clarify this essentially for her, okay? Doesn't negate the responsibility she had under the old order, just to be clear about that. My continuing concern with what Your Honor has entered, and perhaps it can be resolved as some sort of, I'd ask the court to consider some sort of oral amendment, is this. It is on pages 4, number 1, second sentence under number 1, the phrase "or to be involved." Page 5, number 2, line 3, the phrase "or to be involved." And page 6, the first full paragraph after number 5, the phrase "or to be involved." It is possible to read this that a witness, someone who is not now a witness and has made a statement to the media and then becomes a witness later on, and we don't know, okay, could theoretically be subject to a show cause order because of the language to be involved. So that is why I had suggested to the court, and I think Your Honor has the copy of what I previously submitted as my proposed revised. And I'm happy to provide this to the court again. And I asked the court to at least, if not interlineated on this, to state this orally. We drew a distinction that witnesses who give statements to law enforcement personnel, representatives of the Harris County District Attorney's Office, or who testify in investigative or adjudicative proceedings after the date of entry of this order shall not discuss the case with media. So the distinction I was trying to draw was they can say whatever they want until they become a witness. At that point, this order kicks in.
Okay. I think if I'm
I may be misinterpreting what you're on.
I don't think this mentioned the bullet points that you brought up. I don't think it mentions witnesses. It just discusses attorneys, their offices, staff, employees, interns. So it goes specifically to the lawyers and their teams, for lack of a better word, and does not discuss the witnesses specifically. Oh, wait, never mind.
It does in number 2.
It does in number 2. So you'd be requesting a definition of witnesses, or when that kicks in for witnesses for clarity.
Yes, or something like that. And again, my approach, I'll give you what I
Absolutely.
So what I'm looking at is the distinction I was drawing was on number 3 and number 4.
Okay. And this is from the state's proposed.
That was the
previous
yes,
order,
Judge.
Page 8, 3, and 4.
But to be clear, whatever you sign today and enter, I will send an all-employee email.
Sure. Is there any objection from the defense to me orally saying that witnesses who have previously given statements to law enforcement personnel or representatives of the Harris County District's office, Attorney's Office, or who have testified in investigative or adjudicative proceedings would be prohibited from discussing this case with the media? Is there any objection to including that to the order?
No.
Okay, so I can orally say, yes, I'm okay with including that within the order, with the caveat of if they do wish to make a statement, we need to have a discussion because we're limiting First Amendment rights. So I would need to make it clear for the purpose of the record and for this order to hear what needed, that that is adjustable should they want to discuss that and want to exercise their First Amendment rights. We have to litigate that again. So, I agree to that, but with the caveat that it would be without permission of the court. So if the court gives permission, then they would be able to make statements. So they affirmatively have to ask. If they do, we'll discuss it, all of us. So yes, as to page 8, numbers 3 and 4, I would incorporate those orally into the amended order that I filed today.
Okay.
And I guess with that caveat, what I would ask is that the district attorney's office then be pretty careful about what sensitive information they share with witnesses, family members, things like that. Because I wouldn't want that to be an end around to the court's order.
And the court's order obviously limits the lawyers, and I'm going to say teams for just lack of a better word, because I don't want to have to say employees, interns, everything a million times over. That would include you could not use a third party to do the same. So telling somebody information that they then disclose, if you know they're going to disclose it, or it's reasonable to believe that they're going to disclose it, at the very least tell them you can't disclose this. It could impact the integrity of this proceeding and could have potentially a harmful impact on the eventual trial of this case. So let your witnesses or other people involved make sure they're aware.
This administration understands its professional responsibility.
Absolutely. Any other questions so far as to the amended order?
No.
Okay. So I'm going to make sure that the one that I signed this morning is filed. I've made those oral amendments, and perhaps if necessary, I could include them on an additional amended order should it need be. But for the time being, we have a transcript. We will have a transcript of this proceeding. It's there.
Very good.
All right.
Thank you, Your Honor.
What else do we want or need to discuss today?
Your Honor, if we can, regarding our client, we concur with all that. We don't see any reason to proceed unless you want to, but we're in agreement.
Okay. So this is as to Mr. Martinez Rangel's case. Let me get the cause number so we can have this for the record.
I believe his cause number is 1873328.
Yes. So as to that cause number, defense counsel wants an identical order with the identical oral admonishments, but with Mr. Martinez Rangel's name and cause number applied.
That's correct, Your Honor.
I will make sure that order gets filed today as well. It'll look identical, but for the purposes of this proceeding, those same oral additions or amendments will be incorporated into that document as well. All right.
So I guess the only thing outstanding is direction from the court on the contempt hearing itself.
Sure. So I have thoughts and potentially questions. One, I believe that there was discussion of state bar grievance being filed that contained similar, if not identical, subject matter from both sides. Have those been filed? Are they going to be filed? Do we know? Is that something that we're comfortable discussing?
You're putting me in a tough spot, Judge.
Okay.
Because it's a confidential proceeding.
So without going into whether or not it's been filed, would anything that happens here on identical subject matter stop those proceedings, or vice versa? Would state bar grievance proceedings on the same subject matter potentially stop this court from proceeding should one resolve before the other? Do we know?
I don't think so, because one's criminal, one's administrative.
Okay.
We're in agreement on that assessment as well.
That's one of the things I thought. If it were filed, which I know because those proceedings are private in nature, unless there was a public reprimand, a suspension, disbarment, something that happened in the public eye, the results would also be private. So we would not, it might not make sense to wait for that process if one exists to play out before discussing contempt here. So the relief requested by both parties in their, I believe the defense filed a motion and the state filed only an order, the defense filed an order as well. I believe that the only relief requested was criminal contempt, not any of the other powers that this court might have, such as requiring education or other sanctions. So I have to think about, I believe that in order for contempt proceedings to proceed, there has to be a motion, it has to be an order. There is a motion, but I believe the motion does not include other powers that the court may have. So I'm a little hesitant at this time to sign off on either order, but in the same vein as the grievance, I know there's in my order reference to 3906 and there are other things. Does criminal contempt stop any other potential avenues, not including state bar grievances, from proceeding? Because it is criminal in nature.
No.
Okay.
Here would be the distinction, Judge. And I would ask Michelle to chime in as well.
Sure.
For civil contempt, okay, what you are basically doing is you are enforcing compliance.
Okay. I thought this was requesting a criminal contempt.
This is, so for civil contempt, right, like you just, you didn't show up at court, right? You are, in essence, you're fining the person, right, in order to come into contempt, in order to come into compliance. Criminal contempt of a court order, the criminal contempt of court is either direct or constructive. Direct is in front of you.
Yes.
Right? Constructive is outside of the courtroom. You are enforcing, not compliance, you are enforcing non-compliance with a specific order of this court, of you. It's not so it is punishable by fine and no jail time, but it is also punishable by jail time. I think what's up to 30 days?
I believe so.
Right. And what is the $5,000 fine? $3,000?
I have to check. Judge,
So
agree, but for criminal, it's punishing not following the rules, and civil would be enforcing for the future. So criminal would be punishing for what has already happened.
Okay. And I guess for practical purpose, the whole reason we're here discussing a protective order and contempt is everybody involved, the court, both sides, are trying to do everything possible to protect the integrity of the proceeding so that everybody's goals can be accomplished. We want to make sure that the state has a fair opportunity to present the case they want to present, as well as the defense to have a fair opportunity to litigate the case the way they see is in their best interest, without outside factors, outside influences, or additional unneeded media attention or other attention that could potentially impact the jury pool, force a change of venue, or set up error before trial even begins. I don't think we've gotten there yet, obviously. I think we're in a good position. I think that things are still fine. But from a practical perspective, I have concerns that at this time, a contempt proceeding potentially could draw more unwanted attention, give an additional, microphone to parties involved to potentially taint or complicate proceedings at this time. The old order that I had signed on September 11th, my intention, and I believe it could be read as such, was that it applied to everybody whether they maintained their employment or not. And I think that the rules of professional responsibility make that crystal clear. I do see how it could potentially be read otherwise. I know the last hearing and today again, making it clear my intention and my reading and my understanding of what I signed was that it did apply even after leaving employment, because it cites the rules, and those rules are very clear that you leave government employment, those same rules are in place. But at this time, since a new order is in place, I want to hold off on signing a show cause order today to see if this new order potentially solves the issues, as well as I just want to make sure that other claims are not stopped or that other powers the court may have in terms of sanctions or other things are not limited or unavailable if I sign off on the specific show cause order that either side had filed or some cobbled together version of both. So it's not a no, it's a no for today. So the court could perhaps be a little more comfortable with what is available. I do want to make sure that this new order is disseminated to anybody that either side believes needs to be made aware of its existence. Clearly, because we've discussed it, Kim Og herself, and I know there's been reference to first assistance and other things. So I want to make sure that that has been received. But any questions, commentary, requests at this time? Obviously, everything we're doing today can be relitigated as things advance.
Yes, Judge. Just to clarify, because if we're thinking of it as an injunction, that would be for civil contempt, and that's not what we're asking for. Because what I believe what the court is saying is, does this fix any future problems? And that would be civil. And we're asking for criminal punishment for statements that are already public. So we don't believe that it would further bias beyond what's already happened.
Order, Judge, at this point, we have a duty to protect our clients' Sixth Amendment rights. If you recall, in the September 11th order, you have the exact same language, pretty much. The court shall consider sanctions and as appropriate for violations of this order. Even in our hearings where we were operating under oral orders, you made it very clear that the district attorney's office was to report back to former Democratic District Attorney Kim Og that these orders were punishable by contempt. And so if we're looking at both the civil side of it and the criminal side of it, the court has actually probably done the civil side by issuing a more clarified order, but it has not addressed the violations of the previous order. And that's very concerning to us because ultimately if the court takes an overly cautious position on this issue, I can't see a scenario where the former Democratic District Attorney decides that, well, the court isn't going to sanction me, so why should I follow this order?
And Judge, we filed a supplemental motion last night detailing 2 interviews that she, former District Attorney Kim Og, has given in the last week or so. One was to the Houston Chronicle, and one was an appearance at the Kingwood Tea Party meeting, I believe on Monday night. We included their flyer in there, and they billed it as something to the effect of, well, they can issue a gag order, but they can't gag us, or something to that effect. And so she references the case that she can't talk about, bringing more attention on it, being cute and flippant about her past violations of the court's order.
And I have not had an opportunity to review that.
Can I say something?
Absolutely. Absolutely.
With all due respect, I don't disagree with anything as to how necessarily you framed the matter before you. I take, however, something of a little bit of a different perspective as to what the true issue is before you.
Sure.
And this is, I'm quoting now from the Chronicle, Houston Chronicle's reporting of Kim Og's speech to the Kingwood Tea Party. Quote, "Now, I've been silenced by the court on that case. When I gave interviews a few weeks ago, I was not under a gag order," Og said. "Now I am. So we'll leave it to the fact that I'm against the rape and murder of little girls. Are you?" No person, no attorney, can breach a court order.
Okay? I submit to you that Kim Og giving a speech and saying, I was not under a gag order, is Kim Og flipping this court with proverbial bird. Right? And what she did, and it's their motion, we're unopposed, it's a very unique situation, right? What she did is, in my opinion, quintessential contemptuous behavior. And no licensed attorney in the state of Texas should be able to avoid a contempt proceeding for violating a court order and for leaking confidential information about an ongoing criminal investigation. Full stop. So,
yes,
so I understand the court's concerns. They are weighty. And to be clear, this is not a situation that any of the counsel around you have created. Okay? This is a situation created by an extraordinarily selfish human being who believes that the orders of this court do not apply to her. So I look at this situation somewhat differently than Your Honor. I do not believe that any proceeding, should you decide to undertake one, would interfere with the state bar's issues, an examination of what has been conducted, what has occurred, and any grievances that may have been filed. Nor do I believe it would preclude any possible future actions by this court or by this office. I cannot fathom a scenario more serious or, quite frankly, more necessitating a contempt proceeding than this one.
And I will say what was just brought to this court's attention does change the tenor of things. It sounds like, and I obviously have not read the June 17th filing, I will take time to read it and all attachments, but it sounds like the allegation is that the former district attorney acknowledged notice and receipt of a protective order limiting speech, and upon acknowledging it, then spoke in violation of the order she just acknowledged existed. So I know I have this order against me. Let me violate it by saying these things. Is that what is alleged?
I mean, again,
more or less.
I mean, here's what she said. Now, I've been silenced by the court on that case. When I gave interviews a few weeks ago, I was not under a gag order. I said, now I am. So we'll leave it at the fact that I'm against the rape and murder of little girls. Are you? So again, here's an individual who now says, I understand I'm under a gag order, but I'm going to opine again on their guilt and innocence. This is a licensed attorney in the state of Texas, board certified, more than 36 years. Okay. Judge, you need to hold contempt hearing.
Understood. So every word after "now I am" is an opinion on the case being made in a public forum.
Correct.
And there are other statements and acknowledgments.
And
I believe that she's going to continue to do this. My goodness, she was doing this Monday night.
My initial concerns were twofold. Obviously, stopping any future inappropriate communications, as well as addressing previously made statements that were in violation of court orders and or state bar rules. My biggest concern was if we are to try to maintain or limit any potential taint on this proceeding, that by shedding more light and giving a stage to somebody who might speak out more and more, might complicate things or exacerbate where we're at. But what it sounds like is both sides believe, and I'll read this filing, it sounds like it indicates that even after knowledge of the order, statements are still being made. So whether there's a contempt hearing or not, these statements are going to continue to be made, and any taint, if any exists, having a contempt hearing is not going to make it any worse. So in light of that, I do need to reevaluate that. Because if statements are made after acknowledgement of it, that one concern, frankly, is not as much of a concern anymore.
And frankly, that was our thought process in December.
Exactly.
Before she left. And what we were incorrect about was that, oh, she's leaving office. She will move on to her next endeavor and not continue to taint this case with her comments to the media. We were wrong about that. And
very wrong.
I think her Houston Chronicle interview and her appearance at a political function on Monday night only serve to underscore that again, that she is going to continue to use this criminal case to launch her next political career or whatever her motivations are. And she's not going to stop until someone makes her stop.
I can't speak to what her future aspirations, the former district attorney's future professional or political aspirations are. Quite frankly, I don't care.
Yes.
What I care about is I have a former member of the prosecution team continuing to violate this court's gags order and complicating the prosecution of an extraordinarily serious case. And as the chief legal officer, general counsel of the office, I can't tolerate that.
What I'm hearing is the state of Texas effectively has an ultimate goal of prosecuting this case and attempting to see that Mr. Peña and presumably his co-defendant are executed. The defense obviously has the opposite goal, but it is the state's position that their ability to do that gets more complicated when a former member of the prosecution is undermining their ability to proceed the way they believe they need to proceed without extra unnecessary or inappropriate attention, as well as bar rules being broken, more light being shed on that, and effectively a previous member of the prosecution, former DA, claiming they want, I guess, the harshest of punishments while acting in a way that might undermine the state's ability to get there.
I would characterize it as the purposeful and selfish violation of due process.
Okay.
And I would also say with regard to the court's concerns about the status of a bar grievance or other prosecutions, from the defense perspective, while those things might be nice, our only goal here is to protect Mr. Peña's right to a fair trial. And that has to supersede all other concerns about how it may affect collateral proceedings.
Absolutely. Both sides want a fair trial where the rules are followed. Both sides want to fight hard and fight fair. State wants to see the ultimate sentence. Defense does not want to see that. And the only way that the proceeding can happen correctly is if both sides and the entire process is handled appropriately, fairly, everybody following the rules. So whatever happens at the end of the day is lawful and appropriate. So I do think I need to reassess. I'm going to read the filing from last night and let me see what I can cobble together and consider. If I have any further questions, because there's a couple of things I want to look into, I will reach out to both sides and we can discuss. Just thinking, I understand civil contempt does not preclude potential criminal proceedings. I'm concerned that criminal contempt potentially could, and I don't know if that is something that the sides have thoughts on or would be comfortable with, but let me do my own looking into that, and if both sides have thoughts or...
My suggestion is this, is that when I'm volunteering Ms. Schultz, she and I will, I think over the next hour or two, try to email you some, and staff counsel, some pertinent cases, but there's a big distinction between civil contempt and criminal contempt.
Absolutely.
And Judge, we would re-urge the motion that we've already filed, especially since the court has stated that attorneys who previously worked for the old administration, not the current one, were under the protective order or gag order, as she calls it. So the state can choose, since they're the prosecuting attorneys here, which specific instances to go forward on. The court would not be making a finding by allowing us to proceed on that at this time. The court would be allowing us to try to prove it. So if the court would give us the opportunity to do that, I do think that the May statements specifically should be prosecuted as well.
So in theory, if a show cause order were signed, proceedings began to be able to litigate and get to the bottom of things, if a finding is not made or is withheld for the future, nobody's precluded from doing anything or stopped from doing anything because no finding has been made. So
Yes,
at
sir.
least give you all the chance to litigate. Is that what I'm more or less hearing?
Yeah, yes, but again, I think that Schultz and I do disagree. And with regard to the proposed order that they gave you last time, I do not think, I understood there was a check mark for this or not for that.
Yes.
I get it. I don't think there was sufficient notice there. And I also think, honestly, even what I gave you now is going to have to be amended because the statement, now I am, so we'll leave it at the fact that I'm against the rape and murder of little girls or you, would constitute a violation of the gag order.
Judge,
Old one and new one.
just to have the schedule kind of in front of the court and on the record, we already have a July 28th date set. I believe the court would have, I'm not trying to schedule the court, but I do believe that there would be more than ample time to give the former district attorney notice, more than 30 days notice at our current rate.
Sure, it's June 18th today. It's almost roughly 40 days.
I just think we need to get somewhere.
Yeah, let me accelerate my process on this and see if I'm comfortable signing a show cause order quickly. And if I have questions or anything like that, I'll reach out to both sides. I just want to make sure everything is done meticulously. So, anything else to put on the record today?
No, Judge.
Thank you, Judge.
Thank you.
For sure.
Thank you.
Good to see y'all.
Okay, so I'm going to show y'all the video. This was May, I think the 28th, if I'm not mistaken, maybe the 26th. She had went on Fox and did a little blurb about the case, and this was after she was told there's a gag order, do not discuss the case. Even as an assistant or as the former district attorney, she still should have kept her mouth shut. But here it is. I'm gonna let's see full screen.
Anthony Antoine. New evidence is being made public in the Jocelyn Nungaray case only here tonight on Fox. It's been almost a year since this brutal killing shook the nation, and our Fox
Hang on, let me see if I can get the sound up a little bit better on this thing.
26 Abigail Dye has an exclusive interview tonight with the former district attorney Kim Og, who's
I can't
sharing
get it
a
any
shocking
louder.
development.
So you're saying this isn't the first time that Peña has been accused of rape?
That's correct.
To just know that this happened to another woman, it hurts my heart. Really, a piece of me shatters a little bit.
June 2024, 12-year-old Jocelyn Nungaray's body was found in a bayou on West Rankin Road. Two undocumented Venezuelan nationals, Johan Jose Martinez Rangel and Franklin Jose Peña Ramos, are charged with capital murder, accused of sexually assaulting, then killing Jocelyn. Kim Og was the Harris County District Attorney at the time. Her office gathered the evidence they needed to seek the death penalty in the case. And now she's revealing a key piece that helps secure that option.
What we learned during the course of the investigation was that one of the suspects, Peña, had been involved in a prior sexual assault.
She says a victim from another state was attacked while on vacation before Jocelyn's killing.
It happened in Costa Rica. It happened to an American citizen who came forward with that information after their pictures were shown on national television.
I'm very glad that this young woman had the courage to come forward.
That evidence specifically helped you make this determination for seeking death.
I believe it helped the entire committee make the determination.
Is this information that you had ever known, or is this new to you too?
This is definitely news to me. I always felt in my heart that this was never their first time, especially Peña.
Why are you sharing this now?
Because I am very concerned about the decisions that my successor district attorney has been making. When she reported it to the authorities in Costa Rica, they did nothing. And so imagine the frustration of that individual. I do not want that to be swept under the carpet. I think it's important for the public to get the final say. Do they deserve death for the rape and murder of Jocelyn, or should they spend their life in the penitentiary? What I don't want is some backdoor deal done in the quiet of the night and a long time from now, once people have forgotten the horror of this case.
I see this as a reoffender scenario, and because he wasn't held accountable for his actions when he did this to this other young woman, he should be held accountable for this young child whose life was taken.
So basically she's saying, August saying she doesn't want a backdoor deal. So that's why she's speaking up, making sure everybody knows what he's done to other people. But then they're like, okay, so where is, is she using it for her political gain because she's going to do something else politically that we don't know about? So that's where the problem lies. So we'll have to wait and see if she is held in contempt. She did not show up in court today. She was a no-show there. But I do want to share something.
Well, a wildlife refuge in Chambers County is now officially the Jocelyn Nungaray Wildlife Refuge. Jocelyn was only 12 when she was violently murdered in Houston last summer.
Her mother, Alexis, was there Tuesday when President Trump named the refuge in Jocelyn's honor. Abigail Dye spoke with Alexis one-on-one today about what this means in her fight for justice.
9 months ago, 12-year-old Jocelyn Nungaray was killed right here. Here in North Houston, her story is honored with stuffed animals, flowers, and windmills. But about 60 miles east of here, her story is now honored with open water, open skies, and open land where her name will live on.
Knowing that she'll be surrounded by so much water, so much freeness, animals being in their natural habitats, it's very bittersweet. I'm honored to be her mom.
Alexis Nungaray was in D.C. when President Donald Trump gave the Anahuac Wildlife Refuge a new name, the Jocelyn Nungaray Wildlife Refuge.
Alexis, I promised that we would always remember your daughter, your magnificent daughter. And earlier tonight, I signed an order keeping my word to you.
I had no idea that was going to happen. It was a really big shock and surprise. I was kind of stunned. Like, I didn't really know how to react. It was very surreal. It was very bittersweet.
The Jocelyn Nungaray Wildlife Refuge is a federal refuge. It's nestled between Galveston Bay and FM 1985. It has miles of wetlands and trails, and the purpose of it is to preserve wildlife and nature in the area.
She loved and endeared animals so much that it was like a piece of her heart will always be there as well.
As a piece of her is in so many hearts. Jocelyn Nungaray was killed by 2 undocumented Venezuelan nationals in June of 2024, according to police. Her mother has been on a plight for justice since then, feeling that purpose every time she comes back to the scene.
It reminds me of all the fight she had left in her, using it here to defend herself as best as she knew how to, as a 12-year-old could.
And now that strength will always live on here.
She had aspirations to save all the animals, and she had aspirations to be famous, and she just somehow knew everyone would know her name. Somehow, some way, she always said it to me. She said, "Everyone's gonna know my name one day, Mama, I promise." I don't know how she knew it, but somehow, I guess in her spirit, she did.
So that's kind of stuff always chokes me up. Y'all know I end up crying at the end of some of my streams. Here's a couple of extra pictures of Jocelyn enjoying life. And the wildlife refuge that used to be in Anahuac has been renamed for Jocelyn. And it's a beautiful place. If you've ever been there, the wildlife refuge is beautiful. I love wildlife. I love going into nature. I love fishing and all that. All right, Abellis, you have a great night. Thank you, love. But that's a beautiful sunset at the National now Jocelyn Nungaray Wildlife Refuge. So on that note, I want y'all to have a great night, and I plan on keeping y'all updated with the Jocelyn Nungaray case as best as I can. And for now, peace. Rubber out. Y'all have a great night, and I'm gonna go take care of these animals.
Life's a ride on a